Old Order Amish are a religious group who trace their roots back to 17th century Switzerland and Germany. They originally settled in eastern Pennsylvania. Today, there are over 250,000 Amish living on farms and in communities in several states, including Wisconsin. The Amish reject most modern technologies, including electricity, phones, and automobiles. They're known for their simple living and strict adherence to the principles of the Amish Mennonite Church, including humility, modesty, family, and a strong sense of community. The Supreme Court case of Wisconsin versus Yoder highlights the intersection of religious rights, school attendance, and state laws.
Hi, I'm Doug Ginsburg, and I'm a federal judge. There have been times when the law of the land has clashed with deeply held religious beliefs. Wisconsin versus Yoder is such a case. In 1972, Jonas Yoder and two other members of the Old Order Amish religion were prosecuted under Wisconsin law for refusing to send their children, aged 14 and 15, to public school beyond the 8th grade. They were convicted, and Yoder appealed to the United States Supreme Court. Wisconsin law required children to attend school through age 16. The state had reasons for this that had nothing to do with religion. As Thomas Jefferson wrote, "An educated citizenry is a vital requisite for our survival as a free people." Still, Yoder argued that Wisconsin law was inconsistent with Amish religious beliefs. The Amish believed that elementary education, that is, through the 8th grade, teaches their children the basic reading, writing, and math skills necessary to read the Bible and to be good farmers and citizens. But they believe that high schools and colleges teach values that are inconsistent with Amish values and with the Amish way of life. The central issue before the Supreme Court was this: does Wisconsin's compulsory school attendance law violate the Amish parents' right under the Free Exercise Clause of the First Amendment? In the Bill of Rights, the First Amendment to the Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Free Exercise Clause recognizes our right to believe and practice our faith, or not, according to the dictates of conscience, not of government. The court reasoned that an individual's interest in the free exercise of religion under the First Amendment outweighed the state's interest in compelling school attendance beyond the 8th grade. After oral arguments, the justices voted 7-0 in favor of Yoder. Chief Justice Berger authored the decision for the court. 6 other justices joined in that opinion. There were only 7 justices because 2 justices had joined the court after the case was argued and recused themselves. The court concluded that the values and programs of high school were in sharp conflict with the fundamental mode of life mandated by the Amish religion. The ruling was significant because it upheld the Amish people's right of free exercise against an important state program in terms of requiring children to go to high school, which would, in the words of the court, have gravely endangered, if not destroyed, their free exercise of the Amish people's religious beliefs.
Wisconsin versus Yoder was decided in favor of Yoder by a 7-0 unanimous vote in 1972. The key principle was the Free Exercise Clause of the First Amendment. The court ruled that compelling Amish students to attend school past the 8th grade violates the Free Exercise Clause of the First Amendment.